Hey guys, it's Joel Williams and Chase Elleby coming to you today with week number 14 out of our video series of 52 weeks of personal injury. Today we want to talk to you about the burden of proof in a personal injury civil case. So Chase, generally what is the burden of proof in a personal injury civil case?
So generally the burden of proof is called, or is what we call a preponderance of the evidence, which is basically more likely than not. Okay, did the action, car wreck, slip and fall, did it more likely than not cause the injuries? Is the person who committed the act, did they more likely or not breach their burden of care? So that's generally what it is. You want to explain kind of how the burden works and what duties certain people have in order to show what we have to prove?
Yeah, so generally when we talk about the burden of proof, we're talking about what the person bringing a claim or defense has to meet, or what standard they have to meet in order to win or prevail in their case. So for example, we'll take something real simple like a car wreck.
Right.
If someone, when we pull up to a red light, everybody has a duty to stop at the red light and yield to other traffic. And if we breach that duty, then we could be liable for injuries and damages or whatever damages we cause. But the burden of proof comes in if it's disputed. One person says, no, I didn't run the red light, it was a green light. Then the person that's claiming the damages or claiming injuries has the burden of proving that it's more likely than not that the defendant ran the red light and caused their injuries.
Right.
So you got to prove they acted negligently, and then you got to prove that that negligent act caused injuries and what your damages are.
And for that example, if we needed to prove that they ran the red light, we can do that by independent witness statements. We can do that by body cam. We could do that by the testimony from the parties, right? So those are ways just to prove that specific element of what that act was.
Yeah, absolutely. And I think for trial attorneys and anybody that's trying a case, it's really important to remind the jury that burden of proof is more likely than not, or preponderance of the evidence, because sometimes juries will get it in their mind by watching television, or maybe they've sat on a criminal case before about, beyond a reasonable doubt.
Right.
That does not apply in a civil case. And so it's important for trial attorneys, at least, to constantly remind the jury of what the standard of the burden of proof is.
Right, and you bring up a good point, right? Because everyone's seen the criminal cases. The O.J. Simpson's a great example. He's found not guilty of committing a crime, but he was found liable for causing the death, right? Because the standards are completely different. So yeah, it's very important to educate the jury on that, because we'll get jurors that sit there and think, wow, it might have happened this way, it could have happened that way, but I wasn't 100% certain. Yeah. Well, 100% certain is not the standard, and it's our job, and it's very important for us to explain to the jury what it is that they need to get to in order to find in favor of us.
That's right, yeah. Coulda, woulda, shoulda does not play in a civil case. It's preponderance of the evidence are more likely than not. Now there are a few exceptions to that rule where the burden is by clear and convincing evidence. That's not the vast majority of cases, but if you have a personal injury case, and let's say it's in Georgia and it's in an emergency room or an emergency medical setting, then a clear and convincing evidence standard may apply. But in most of those situations, you better have an attorney anyway that can describe that and explain to you what the difference in those standards are. So, but I guess for the most part, all in all, just remember that for most civil cases involving personal injury, that you have to prove it's more likely than not that somebody acted negligently, it's more likely than not that the negligent act caused your injuries, and then you got to prove what your damages are. Really as simple as that.
Yeah, that's it. I think we did a good job narrowing it down.
All right, good deal. Well, we appreciate you spending time with us and watching this video today. If you enjoyed the video or learned something, hit that subscribe button, hit the thumbs up, give us a like or a comment if you can think of any other burdens of proof that may apply to civil cases. Otherwise, we will see you next week for video number 15.